This, in my opinion, was on a moderate side, okay, as compared to the first question. This one says that comment on the need of administrative tribunals as compared to the court system. So we all know that administrative tribunals have been set up in India after the 42nd Constitutional Amendment Act and the Administrative Tribunals Act of 1985 made under provisions of 323A. Uske kya reasons hain? We'll just come to that. So what were the reasons, or what is the rationale for setting up administrative tribunals? Assess the impact of recent tribunal reforms through rationalization of tribunals made in 2021. UPSC 2021 को recent बता रही है, which is an anomaly in its own, but anyway. How do we address this type of a question? But before that, let's quickly talk about what are the things that you need to prepare as far as the topic of tribunals is concerned. So, in tribunals, one, you need to understand what is the objective behind setting up of tribunals in India. वही पहला part of the question है. Second, in the topic of tribunals, you also need to prepare what are the significant judgments of the court related to tribunals. If you know about some of the important judgments of the court, such as the Sampath Kumar case, L. Chandra Kumar case, if you know about the judgment of the court in the Madras Bar Court, in the Madras Bar Association, you would already be able to answer the second part of the question as well related to tribunals. Third, you need to know what are some of the challenges associated with the functioning of tribunals in India. Fourth, what are the reforms which are required. And of course, related to all of this, you need to know the respective constitutional provisions that you would anyway prepare for your prelims portion as well. So these are the things that we need to prepare as a part of our topic of tribunals. Firstly, let's understand what this question is about. अब वो ये कह रहा है, assess the need, और क्या था? What was examine था? कुछ था? हाँ. Comment on the need of administrative tribunals as compared to the court system. As compared to the court systems. ये बहुत important चीज है. Why are administrative tribunals preferred, or why did we set up administrative tribunals in our country to deal with certain matters when we already had the court system? That's the thing. Now, again, in this question, the introduction can be very straightforward. You simply start with Article 323A of the Indian Constitution, which allows for setting up administrative tribunals in India as per a law of the Parliament. So Article 323A basically says that Parliament can make a law and can set up administrative tribunals in India. What are these administrative tribunals supposed to do? Administrative tribunals are supposed to decide disputes related to service matters. Service matters of government officers. So administrative tribunals can be set up for deciding the disputes related to promotion, related to salary, allowances, pension, dismissal, recruitment. All these are service matters which can be decided by the administrative tribunals in India. And for this, Parliament can make a law. A law was made by the Parliament in 1985 as per the provisions of Article 323A, which is nothing but the Administrative Tribunals Act of 85. ठीक है, already इतना सारा fodder हमारे पास है. But now, why were these administrative tribunals set up when we already had the court mechanism? That's the answer that we need to provide to the examiner. Now, what was the need for setting up these administrative tribunals? Administrative Tribunals Act of 1985, what is the need for setting up administrative tribunals? First and foremost, the administrative tribunals in India, and we have to compare it to the court system. The courts in India apply rigorous laws and procedures. कोर्ट्स जो हैं वो rigorous laws और procedures apply करते हैं. For example, they apply the Evidence Act or they apply the Civil Procedure Code, etc. These are rigorous laws. They are highly technical in nature, and you need to go through the rigors of these laws, which means you will present evidence, the other party will present evidence, then examination of evidence, cross-examination of evidence, cross-examination of witnesses, etc. Everything will happen, and then the judge will go into it. So एक बहुत ही detailed procedure follow करना पड़ता है technical. In case of administrative tribunals, there is no need to follow all of this. You can simply replace all of this with principles of natural justice. So because they do not follow these rigorous legal procedures which have been mentioned in Evidence Act, CPC, etc., as a result of that, they are faster in justice delivery. So it leads to faster justice delivery. अब आपने जब ये लिखा, how can you differentiate from your competitor? Talk about that it helps in achieving the goals under Article 21 of the Indian Constitution, or it helps in achieving the goals under Article 39A of the Indian Constitution. That's where you will get extra marks. Okay. So one. Secondly, the administrative tribunals as compared to the courts. ये बड़ा important है, बार बार courts का reference लेके आना. Courts charge a hefty fee for filing of the case. In case of administrative tribunals, this amount is negligible. 50 रुपए लगता है literally. So it is a much cheaper way of accessing justice as well. So now why is this preferred? Because it helps in ensuring that all social classes can get access to justice irrespective of whatever their economic status is. Third, as compared to the regular courts, the administrative tribunals are supposed to be manned by not just people with judicial experience, but also people having specific technical expertise in administrative matters. So as a result of that, the quality of justice that is provided at these tribunals is much better as compared to the regular courts, because they consist of not only people with a judicial background who are called as judicial members of the administrative tribunals, but they also have technical members. So this is another advantage of the administrative tribunals. Then another important point with respect to administrative tribunals, accessibility. We have multiple benches of administrative tribunals across the country. The high courts are limited in nature. There are 19 circuit benches of the Central Administrative Tribunal in the country. Because of that, accessibility of the common man to these tribunals is much easier as compared to the regular courts in the country. So that is also something which you can talk about. So because of these reasons, we needed these tribunals in country. Now, at the same time, it says in the second part, assess what has been the impact of the reforms which were introduced recently with respect to administrative tribunals in 2021. So when you have to talk about these impacts, now this second part of the question is slightly tricky, but if you have read the topic of tribunals well, even if you do not exactly know what happened in the 2021 Act, you would be able to write some of the things. Reforms चाहिए क्यों? क्योंकि कुछ problems हैं with functioning of tribunals, administrative tribunals. So you can just mention that as a passing reference. So once you have mentioned all of this, then you mention passing reference. Certain problems of administrative tribunals in India. Problems are that we have ended up setting up too many tribunals in India. And ab dekhiye, second part of the question is not just about administrative tribunals, but it is about tribunals in general. So we have ended up setting too many tribunals in India, and it has led to what is called as tribunalization of justice. So in fact, second part of the question doesn't need you to talk about administrative tribunals per se. Just इसको बस passing reference दीजिएगा. There has been tribunalization of justice. Increasing number of tribunals have been set up in India, which have, in opinion of many people, replaced the high courts in the country. Second problem is, और इसी से related reform भी है. Reform क्या था? You ended up setting too many tribunals in India, creating chaos, replacing the high courts. People started to say tribunalization of justice is happening. Secondly, what was happening was there was shortage of manpower. Because of that, many of the positions in these tribunals were lying vacant. तो सरकार ने क्या बोला? In 2021, let us rationalize the number of tribunals in India. Rationalize tribunals, which is basically abolish certain tribunals. What the government did was that not only did they abolish certain tribunals, but they gave the jurisdiction of certain appellate tribunals. So over these tribunals, you can have appellate tribunals as well. So they gave the jurisdiction of certain appellate tribunals to the high courts. So abolished the tribunals, ये reforms की बात हो रही है. And what they did was they restored jurisdiction of high courts instead of appellate tribunals, where you could appeal the decisions of the tribunals. Second problem with respect to the functioning of the tribunals is excessive executive interference. If you have read the topic of tribunals, you would know that this is one big problem with the tribunals, that the parent ministries were controlling the appointment to the tribunals for a very long time. So if I am Ministry of Finance or I am Ministry of Corporate Affairs, and in NCLAT I only am deciding who the members are going to be, and I am one of the parties, how can I expect the tribunal to be fair? In Sampath Kumar case and in Al Chandra Kumar case, both the cases, Supreme Court of India has stated that tribunals should follow the same efficacy standards as high courts. They are replacing the high courts. So they should follow the same efficacy standards as high court. Otherwise, what will suffer? Judicial independence, separation of powers, part of basic structure of the constitution. तो इसीलिए उनका सेम एफिकेसी स्टैंडर्ड होना चाहिए, उनके अपॉइंटमेंट जो है इंडिपेंडेंट होना चाहिए. सुप्रीम कोर्ट सिंस संपत कुमार केस हैज बीन सेइंग दैट मेक द प्रोसेस ऑफ अपॉइंटमेंट टू द ट्रिब्यूनल्स इन इंडिया इंडिपेंडेंट इन नेचर. तो गवर्नमेंट ने, आइडियली गवर्नमेंट व्हाट दे शुड हैव डन इज दैट as per the judgment of the court, they should have gone ahead and made a search and selection committee and made the process as independent as possible of the executive for the appointment of members of the tribunals. But that has not been done. The 2021 reforms failed to address this problem. तो ये हम assess कर रहे हैं. It failed to address this problem. Because executive interference continued to remain as far as the administrative tribunals is, or the appointment to the tribunals is concerned. Third, there is lack of uniformity in the functioning of tribunals across the country. Because of lack of uniformity in appointment procedure, lack of uniformity in the various aspects of their functioning, the government trying to bring in certain uniformity through this Tribunal Reforms Bill Act of 2021. What was that? Basically, one of the things, for example, what they did was that the tenure of a member at tribunals will be a maximum of 4 years. इससे आपने एक यूनिफॉर्मिटी ला दी in the functioning of the tribunals across the country. But even though this could be said as a movement that helped in ensuring independence or uniformity in functioning of tribunals, it was criticized. Because some people said that why have such a short tenure? You should have given a longer tenure to the members of the tribunals. That way, they would have been able to build expertise and they would have been able to work in an independent manner or without the fear of the government in their mind, that whether we will get a reappointment to the tribunal or not. So that is another thing. Also, another thing which was done was that you introduced maximum age of 50 years for appointment to the tribunals. Again, ये uniformity लाने के लिए किया गया, but this was also criticized. Why? Because people said that you are limiting the talent pool of people who will be appointed to the tribunals. So you could have written some of these points. कुछ चीजें हमें already पता होती है अगर हमने basics पढ़े होते, even if we did not know what the tribunals reforms of 2021 essentially were. Now, this particular tribunals reforms of 2021 were actually heavily criticized by the Supreme Court of India. Why? Because 2 years before, the government had brought in an ordinance to reform the tribunals, and which included similar kind of provisions which were included in the 2021 Act. And that ordinance was challenged in the court and the court struck it down, some of these provisions. और वही same जो provisions थे या similar provisions थे 2021 के act में आप legislative route से ले आए. So why did Supreme Court have a problem? That you introduced something through ordinance route. We said that this is unconstitutional. Now, what did you do? You did not listen to us. You went ahead and passed a law to bring in the same measures which we were not okay with. For example, minimum age of, maximum age of 50 years at which the appointment to a tribunal can happen, and a tenure of 4 years, maximum tenure of 4 years. This is something which was not acceptable. Plus, on top of that, the court had said that you please reform this process for appointment of members to the tribunal by making it as independent of the executive control as possible. So, this is what had to be mentioned in this particular answer. And in conclusion, you could have mentioned about why it is important to ensure effective functioning of the tribunals, or you could have mentioned, आप L. Chandra Kumar case का लिख देते, as mentioned by the Supreme Court of India in L. Chandra Kumar or in Sampath Kumar case, it is important to ensure independent functioning of the tribunals to maintain separation of powers and independence of judiciary in the country. That's it.